In this video, we're going to talk about my top 5 tips for negotiating your divorce. Hi, my name is Sean Palmer with the Palmer Law Firm, and I've been practicing family law in the great state of Texas for the last 19 years, exclusively in the area of family law. And in that time, I've negotiated, must be hundreds of cases involving divorces. And over time, I've come up with the 5 very important tips. Now, there's lots of things we can talk about this, but these are the top 5 basic tips that you'll need to know when you're negotiating your divorce. So let's jump right into it. My tip number 1 is to communicate. Communicate with your attorney exactly what are your goals and your concerns for the future. A lot of times people come into negotiations with positions, and positions are things such as, I want to have the house. But the difference between a position and a goal is that the goal may be, I want to have a stable living situation for myself and my children, which may be different than having that particular house. Goals and interests for your future are going to be key in coming up with creative solutions for your negotiation. And you need to communicate those to your attorney so that your attorney can then in turn fight for what it is that you want and what you need for your future. Okay, so tip number 2, know what you have. So some clients come in and they want to immediately start to negotiate their divorce and without really knowing exactly what the whole marital estate is comprised of. A marital estate is a composition of what you've earned and gathered up as far as material possessions since the time that you were married, all the way to the time that you're divorced, and that includes also the debts that you've accumulated. So clients often come into my office and they say, I want to know, am I going to be able to get half of my retirement? I want to know, can I keep the house? Well, that can only be answered in knowing the larger marital estate. So a amount of discovery must be done before you start negotiating so that we know exactly what it is that we're saying when we're saying we want half of the retirement. Do you want half the retirement and the whole amount of the house? Or what about the debt that's out there? How is that going to be handled? So it's really important to do some at least minimum level of discovery in the case. And that generally begins with the process of gathering, generating, and distributing what we call an inventory and appraisement, which is just simply a spreadsheet that has all of your assets, all of your debts, how those are characterized, either as community or separate property, and the estimated value. Each party needs to come up with that inventory and exchange those prior to any negotiation that's going to be at all meaningful. Because if we're trying to divide up a pie, which is your marital estate, and we're trying to figure out what slice of the pie you're going to get, we have to first understand the shape and size of that marital estate pie. So a minimum amount of discovery is required, and you have to have a good handle on what your marital estate is. Lots of people don't usually know that from one day to the next, except when things are going on like a divorce. So tip 3, know your case. You need to know the merits of your case. You need to understand the facts. You need to understand how the law will be applied, and you need to understand how the judge is going to rule, or jury if that's the way you want to go. Now, obviously, here's where your attorney is going to be the key player in this. But your attorney and you need to understand the merits of your case so that you don't waste time and money in negotiating against the idea of going to court. You could result in a less than favorable outcome if you don't have an idea of what would have happened if you had gone to court. And so you really do need to know the merits of your case. You need to know the facts around your case. That might also come down to issues that you don't quite understand yet. Maybe perhaps things like you inherited some property. Well, what were the circumstances of you inheriting it? Did you get a gift? Was the gift to both spouses? So the facts of what's going on in your marriage and how the judge will decide about who's going to get what percentage of the estate is going to be critical to any negotiation. You have to have a real and realistic understanding of the merits of your case. Okay, tip number 4, know your alternatives to negotiation. The term BATNA, B-A-T-N-A, was first coined in a book called Getting to Yes by Roger Fisher, Bill Urey, and Bruce Patton back in 1983, and it's a go-to phrase. BATNA is best alternative to negotiated agreement. So whenever you negotiate, it's essential that you know what is going to happen if you don't settle there, either in a mediation scenario or just an informal settlement. What would happen if you didn't settle? And you have to know what would be the best alternative to settlement. So you really need to develop your BATNA with your attorney early on in the case, or maybe after the discovery phase is over, so that you know exactly what the merits of any proposal or counterproposal is. Now, BATNA is not going to be a great alternative to you, but it just has to be one little bit better than negotiating the worst offer that's out there. So it's an important reference point to know, and you should decide what that is prior to entering the negotiation, so that you can know. It's a metric to know exactly whether it's a good offer or a bad offer, or how good or how bad the offer is, because you're going to measure it against your BATNA, which you're going to talk to your attorney about ahead of time. And then finally, tip number 5, just be prepared for the actual negotiation. So in property cases, you got to be prepared with a worksheet so that you can quickly evaluate different offers that are going to come back and forth fast and furious. You need to list out your assets and debts. You need to have your budget statement, if it applies in your case, about what your expenses and your needs are going to be moving forward. You need to have copies of your relevant financial documents. That includes bank statements, tax returns, maybe business documents. Basically, all your discovery should be done by the time you're negotiating, so that, again, as we said before, you need to have a handle on what your marital estate is before you start negotiating on it. So you have to know the value of your property, the character of your assets, whether it's separate or community property, and documents to support that characterization. All your debts and liabilities need to be known, and that includes tax liabilities. And also you should have a handle on the tax ramifications if you take on either certain debt or certain assets. You need to know. You don't want to be, kicked in the teeth with capital gains tax if you take that house, or at least if you do, you should know what that is and roll that into your calculation. And then, of course, all legal research should be done so that we know the strength and merit of your case, and know whether or not we should walk away from the negotiation table and go to court. So there you have it, my top 5 tips for negotiating a divorce. If you have any questions about that, you can visit my website, www.thepalmerlawfirm.com, or just leave a comment below and we'll get back with you and maybe answer your question that way. But I hope this has been helpful to you. My name is Sean Palmer with the Palmer Law Firm, where we can't protect your heart, but we can protect your rights. Thank you.